Hi everyone, welcome to the virtual amicus and I am Jay Lodha. So today's topic for discussion would be emergency arbitration in India, and quite specifically with respect to the Honorable Supreme Court's recent landmark ruling, wherein there was a big major blow to retail pioneer Kishore Biani's $3.4 billion bid to sell his assets of Future Retail Limited to the Reliance Infrastructure Group, wherein the Honorable Supreme Court of India had upheld the interim award, which was dated 25th of October 2020 of the emergency arbitrator under the arbitration rules of the Singapore International Arbitration Center, and thereby restraining FRL from going ahead with the deal. Now, what do we mean by emergency arbitration? Now, is every award that is passed as an emergency arbitration award enforceable? When does Section 17 come into the picture? Is every award that is passed as an emergency interim award, is it appealable? So to elaborate further, we have with us a very special young dynamic counsel who joins us from Bombay. We have with us Mr. Anirudh Hariani. And just to give you all a brief introduction about our amicus for today's session, Mr. Anirudh Hariani practices as a counsel at the Bombay High Court, appearing in civil, commercial, and arbitration matters. He graduated from Government Law College, Mumbai in 2011 with a BLS LLB degree. He then pursued his LLM from Cornell Law School and graduated in 2012. In 2014, Mr. Hariani became a member solicitor of the Bombay Incorporated Law Society after clearing the article clerk's examination in the very first attempt. And today he practices as a counsel at the Bombay High Court, specializing civil commercial arbitration matters. He sits in the chambers of Mr. Mustafa S. Doctor, who's a senior advocate. He's also a visiting professor at his alma mater, the Government Law College, Mumbai. And prior to joining the chambers of Mr. Doctor, Mr. Hariani worked with Hariani and Company, advocates and solicitors as a partner. So thank you so much there, sir, for joining us and taking out time on a busy working day. So sorry we spoiled your Friday evening, but
No, not at all.
your
Thank you
loss is
so much for having me, Jay.
our pleasure. Your
Thank
loss
you
is
for
our
having me.
gain here on the virtual amicus. And sir, any introductory remarks before we start with our session?
Sure. So firstly, I would like to thank you, Jay. I think it's a great initiative that you've taken to have these sessions and to spread awareness about legal topics. And the fact that you're getting people from the industry to speak is commendable, and more power to you. Now, on this topic, it's like you said, it's a landmark judgment. Emergency arbitration has been in the works or has been thought of for a long time in India, especially since in all major jurisdictions abroad, there's specific statutory recognition of emergency arbitration. But in India, it's not so as of now. The judgment that we're talking about is the Amazon .com NV Investment Holdings versus Future Retail and Others judgment, which was delivered on 6th of August 2021 by the division bench of Justice Nariman and Gawai of the Supreme Court of India. It's a pro-arbitration and a pro-enforcement judgment. In fact, it's the last in a long line of pro-arbitration judgments delivered by Justice Nariman, including the famous judgments of Associate Builders, Sangyong, etc. He is known as one of the shining lights of the Supreme Court, especially in relation to arbitration law. And therefore, it's a very welcome judgment. I'm excited to talk about it. Now, just a brief background about what is emergency arbitration. Well, it's a mechanism of arbitration through which parties to an agreement can seek interim relief even before constitution of the arbitral tribunal. So it's an option or an alternative to going to court and getting interim relief. It is opted in cases where parties cannot wait for the formation of the arbitral tribunal, and it would cost irreparable loss to the party seeking it. So therefore, that is emergency arbitration for you. Like I said before, it's been in the cards for a long time. In fact, in the 246th Law Commission report, it was suggested that amendments be made for the inclusion of emergency arbitration provisions in the Arbitration and Conciliation Act. Unfortunately, that was not acted upon. Despite that, this judgment, although referring to the fact that it was not acted upon and no amendments were made in relation to emergency arbitration, this judgment expressly allows emergency arbitration and recognizes awards or interim awards or orders made by an emergency arbitrator, so long as these awards or orders are in Indian seated arbitration. Not in all arbitrations, only in Indian seated arbitration, because in that case, Section 17 would kick in, Section 17 of the Arbitration and Conciliation Act. And then under Section 17(2), it would be recognized. But there's nothing in relation to non-Indian seated emergency arbitration awards. And that perhaps will come in a later judgment or may not be allowed at all. That we are yet to see. So this is the brief background. And I'll just briefly discuss what the questions of law that were involved in this judgment were. The first question of law that was discussed was whether an award or an order delivered by an emergency arbitrator who was appointed under the SIAC arbitration rules can be considered as an order under Section 17(1) of the Arbitration Act. And we'll discuss what 17(1) deals with. And the short answer to this question was yes. The long answer, of course, I'll give during the course of this talk. And the second question that was involved was whether an order passed under 17(2), that is for enforcement of the order under 17(1), in enforcement of an award of an emergency arbitrator, can be appealable either under Section 37 of the Arbitration Act or under any other provision of the Civil Procedure Code. And the short answer to this question was no. Of course, we'll discuss it in more detail, but we are primarily concerned with the first question more than the second question, since the first one actually paves the way to permitting enforcement of emergency arbitration awards in India, that is in Indian seated arbitrations. The second question is also important, but it is more procedural, and therefore I won't dwell on that as much as on the first point. Now, why do you say why Indian seated arbitrations and why not foreign seated arbitrations? Well, firstly, Section 17, as I mentioned, only applies to Indian seated arbitrations, and this is apparent, of course, from the whole line of judgments from Balco to Bhatia International, etc. And then the amendment, the 2015 amendment to the Arbitration and Conciliation Act, which amended Section 2(2), which says that this part, that is Part 1 of the Act, shall apply to only those arbitrations where the place of arbitration is in India, provided that subject to an arbitration to the contrary, the provisions of Sections 9, 27, and 37 shall also apply to international commercial arbitration, even if the place is outside India. So we do not fall under that if it is a foreign seated arbitration, and therefore Section 17 does not apply, and therefore foreign seated emergency arbitrator as of now has not been dealt with by this judgment. Now, Jay, if you want to step in at any time, let me know.
Sure, sir. Please go ahead.
Okay, so the next thing that I want to discuss is the facts of the case, and I'll try to keep it brief, but there is a long procedural history, and I'll give you a bit of the merits of the case, but really we're not concerned with the merits. We're more concerned with whether an emergency arbitration award is enforceable or not. But I'll give you a brief background of the facts of the case since it is such a high-profile case. So this case involves proceedings initiated by the appellant, that's Amazon, before the Delhi High Court under Section 17(2) of the Arbitration and Conciliation Act to enforce the interim order dated as Jai mentioned, 21st October 2020, of an emergency arbitrator appointed by the Singapore International Arbitration Center. So this order of 25th October 2020 was passed in arbitration proceedings commenced by Amazon against the respondents. These were SIAC arbitration proceedings. Now, who are the respondents? The first respondent is Future Retail Limited, and it is one of India's largest retailers. The second respondent is Future Coupons Private Limited, FCPL, a company which holds a large shareholding in FRL, that is Future Retail. Large, by large, I mean 9.8 approximately % equity shareholding. And both FCPL and FRL are controlled or are majority owned and controlled by the remaining respondents, who are collectively known as the Biyani Group. In this case, it was agreed between the parties that the seat of arbitration would be New Delhi. Therefore, it was an Indian-seated arbitration. And as per the arbitration agreement, it was agreed by the parties that SIAC arbitration rules shall apply. So although it was an Indian-seated arbitration, the procedural rules were that of the SIAC arbitration rules. Now, as to the facts of this case, there were 3 agreements which were entered into between the parties. There was a shareholders agreement of August 2019, 12th August 2019, entered into amongst the Biyani Group itself, that is the respondents 1 to 13. And under this shareholders agreement, FCPL had a negative right with regard to FRL and had the right to all the FRL's retail stores, material special protective rights, and these are known as the retail assets of FRL. So FCPL had the exclusive right to FRL's retail stores and retail assets. Now, the rights granted to FCPL under that shareholders agreement were to be exercised for the benefit of Amazon, and therefore there was a identical or a similar shareholders agreement entered into between Amazon, FCPL, and the respondents, the remaining respondents, apart from FRL, that is, which was dated 22nd August 2019. Now, on this basis, Amazon agreed to invest a large amount, that is 1,400 crores approximately, in FCPL, based on the rights that FCPL had under the shareholders agreement with FRL. So this investment was recorded in a share subscription agreement, also dated 22nd August 2019. And it was expressly stipulated that the investment in FCPL would be a flow down investment to FRL. So therefore, there was a negative covenant in favor of effectively Amazon. And the basic understanding between the parties was that Amazon's investment in the retail assets of FRL would continue to vest with FRL, and FRL could not transfer its retail assets without FCPL's consent, which in turn could not be granted unless Amazon had provided its consent. So FRL was essentially prohibited. That's Future Retail was prohibited from transferring its retail assets to certain restricted persons who were the prohibited entities, so to speak, and with whom the Biyanis could not enter into any agreement. One of these restricted persons was the Reliance Industries group, that is Mukesh Dhirubhai Ambani Group, which was expressly listed as a restricted person under the shareholders agreements. Then, on the basis of these 3 agreements, in December of 2019, Amazon invested that 1,400 crores in FCPL, which flowed down to FRL on the very same day. So it was a pass-through essentially. Now, the main debate between the parties was that within a few months of the investment, that is in December 2019, within a few months thereof, on 29th August 2020, the Biyani Group entered into a transaction with the Ambani Group, that is the Reliance Industries Group, which transaction contemplated the amalgamation of FRL with the Reliance Industries Group and the consequential cessation of FRL as an entity and complete disposal of the retail assets in favor of the Reliance Industries Group. And this was ex facie in breach of the negative covenant contained under the shareholders and share subscription agreements. And this is not even disputed even in the Supreme Court or in any court in which the proceedings went through. Now, what is the procedural history of this case? As I mentioned, Amazon initiated arbitration proceedings and seeking emergency interim relief under the SIC rules. One senior counsel, who is the former Attorney General of Singapore, Mr. V.K. Raja, was appointed as the emergency arbitrator. And after hearing the parties, passed a detailed, what he calls an interim award, dated 25th October 2020. And in that award, he issued various injunctions restraining the respondents from taking any steps in furtherance or completion of the disputed transaction, which I mentioned above, in favor of Reliance Industries. The respondents thereafter went ahead, despite the interim award, with the disputed transaction, and they disputed the validity of the award, saying it is a nullity as the emergency arbitrator did not have jurisdiction to pass it, etc., etc. And then FRL did not challenge the emergency arbitrator's award under section 37, because 37 is the appeal provision for orders under section 17. But instead, since it disputed that it was a valid award altogether, it chose to file a civil suit before the Delhi High Court, where it chose to interdict the arbitration proceedings, seeking interim relief to restrain Amazon from writing to statutory authorities relying on the emergency arbitrator's award. They said this is tortious interference with the civil rights of FRL. After hearing the parties, a single judge of the Delhi High Court refused to grant interim relief, although it did find that there was tortious interference. Biyani Group did not appeal the order, but Amazon did appeal the order insofar as those observations of the learned single judge are concerned. In the meantime, Amazon went ahead with an application under section 17.2 of the Arbitration Act. We'll get into what is 17.2, etc. in detail. This was disposed of by a single judge. Then the single judge passed a status quo order restraining the Biyani Group from going ahead, etc. An appeal was filed, etc., etc. A final order was passed. I'm not going to go into the details of it. Eventually, the final detailed judgment gave reasons for an order made under section 17.2, enforcing the order under 17.1 of the emergency arbitrator. And it held that the emergency arbitrator's award is an order under section 17.1 of the Arbitration Act. And eventually, for all intents and purposes, the order of the emergency arbitrator is enforceable as an order of the court under section 17.2. We'll get into what 17.2 talks about, but this is just to give you a procedural history. Eventually, the respondents raised various objections. An appeal was filed to the division bench. The division bench stayed the single judge's order, and against this order, special leave petitions were filed in the Supreme Court. And that's why the Supreme Court heard the parties in detail and passed the present judgment, which we are talking about. Jai, tell me if you want me to deal with anything else presently on the facts.
No, sir, I think I'm at peace with whatever you said. You can talk about the issues that were there before the court, and quite in particular, Section 17 of the Act, because it has an
Sure,
important, crucial role to play. Yes.
sure. So now for a moment, let's look at what Section 17 of the Arbitration and Conciliation Act really talks about. And bear in mind that prior to the 2015 amendment, there was a vastly different Section 17 than what we see today. So, what does Section 17 talk about? Interim measures ordered by an arbitral tribunal. And I'm going to read out the section, just the relevant portions. One, a party may, during the arbitral proceedings, apply to the arbitral tribunal, and then they give for appointment of guardian of minor person, for an interim measure of protection, etc., etc. So an application is maintainable before the arbitrator under section 17 for interim relief. And then section 17(2) is very important. It says subject to any orders passed in an appeal under section 37, any order issued by the arbitral tribunal under this section shall be deemed to be an order of the court for all purposes and shall be enforceable under the CPC in the same manner as if it were an order of the court. So that is what section 17 says. 17(1) provides for interim relief, and 17(2) says that an order under section 17(1) shall be enforceable as an order of the court. Okay, so now having said that, let's look at the first issue which the court considered. And the first issue which the court considered was whether the order by the emergency arbitrator, or the interim award as it was termed, is an order under section 17(1) of the Arbitration and Conciliation Act. And the short answer, as I mentioned, is yes. Now, it is a lengthy judgment, and depending on which reporter you read, it is between 50 and 100 pages long. So therefore, I won't be dealing with every single argument and every single observation of the judges, but only the key ones. So initially, the court considered the definitions of arbitration, arbitral award, and arbitral tribunal under section 2 of the Act, and also held that section 2(6) makes it clear that parties are free to authorize any person, including an institution, to determine issues that arise between parties. And also under section 2(8), party autonomy goes to the extent of an agreement which includes being governed by the arbitration rules referred to in the arbitration agreements. So therefore, the parties have the autonomy of deputing an institution to determine issues between the parties, and party autonomy is one of the basic features of arbitration under the Arbitration and Conciliation Act. Moreover, under section 19(2), which deals with the procedure to be adopted by the tribunal, and which says that parties are free to agree on the procedure to be followed by the arbitral tribunal in conducting its proceedings. This is again an emphasis on party autonomy, because ultimately arbitration is a creature of contract. The arbitrator derives the authority from the parties itself, and therefore party autonomy is a vital feature of arbitral proceedings. Moreover, section 21 of the Act provides that unless otherwise agreed by the parties, commencement of arbitral proceedings on the date shall be on the date on which a request for the dispute to be referred to arbitration is received by the respondent. Now, the court held that reading of these provisions, which I mentioned, section 2 of the Act, section 2(6), 2(8), 19, and 21, on the reading of these provisions, it would show that an arbitration proceeding can be administered by a permanent arbitral institution such as the SIAC, The SIAC, the Singapore International Arbitration Center, is essentially an institution which administers arbitration. It is an institutional arbitration as opposed to an ad hoc arbitration. So, moreover, the judges also said that Section 21 is subject to an agreement between the parties. And since the parties had agreed that the SIAC rules will apply, under the SIAC rules, specifically Rule 3.3, the date of receipt of the complete notice of arbitration by the registrar will be deemed to be the date of commencement of arbitration. Now, I won't go into this in detail, but eventually the judges held that since in section 17.1, the expression used is interim relief can be granted during the arbitral proceedings, this expression would be elastic enough so that when you read section 21 of the Act and Rule 3.3 of the SIAC rules, 17.1 would be attracted and emergency arbitration proceedings would fall under the definition of during arbitral proceedings, since since section 21 provides that it is subject to an agreement between the parties. Now, I'm not going to go into detail on section 21, etc. But the court also said that on a conjoint reading of the provisions of the Act, coupled with there being no restriction, either by implication or expressly, against emergency arbitration, this means that emergency arbitrators' orders, if provided for under an institutional rules, would be covered by the Arbitration Act. This is very important. So what they're saying is that since there's no prohibition against emergency arbitration, and since in view of those earlier provisions I mentioned, an institutional arbitration is permissible and you are entitled to go by the institutional arbitration, the institution's arbitration rules. Therefore, even an emergency arbitrator's award or order would be legal under the Arbitration Act. Now, the court also dealt with various judgments. I won't go through each of them, such as the Antrix Corporation judgment, the seminal judgment of Balco, Centro Trade, etc., to emphasize that party autonomy is very important in arbitration proceedings and is one of the main principles on which arbitration is based. And also what they held was that in view of the Centro Trade judgment, the parties to the contract, by agreeing to the SIAC rules and the award of the immediate emergency arbitrator, have not bypassed any mandatory provisions of the Arbitration Act. There is nothing, absolutely nothing in the Arbitration Act that prohibits contracting parties from agreeing to a provision providing for an award being made by an emergency arbitrator. On the other hand, when properly read, various provisions of the Act which speak of party autonomy in choosing to be governed by institutional rules make it clear that the said rules would apply to govern the rights between the parties, which is totally removed from a position where emergency arbitration is prohibited by the Act. In fact, it is endorsed by the Act. Now, I mean, I'm not going to repeat it because the judgment went into song and verse about sections 2, 21, etc., etc. But the short point is that they held that even the meaning arbitral tribunal, because only an arbitral tribunal can, of course, pass an interim order under Section 17. Even the phrase arbitral tribunal contained in Section 2 of the Act does not restrict an emergency arbitrator from making an interim award. In fact, it could include proceedings before an emergency arbitrator. And ultimately, what is the purpose of Section 17 of the Act, or 17(1) of the Act? The purpose of Section 17(1) of the Act is an application for interim relief. There is nothing in Section 17(1) of the Act, when read along with other provisions of the Act, which prohibits the application of rules of arbitral institutions that allow for emergency arbitration. The court therefore went on and emphasized that there's no prohibition on emergency arbitration. The court also held that the respondents had argued that, the arbitration agreement contained in the shareholders' agreement would indicate that the SIAC rules were only agreed insofar as arbitration alone and not insofar as emergency arbitration. So the court held this interpretation is absolutely incorrect because of the SIAC arbitration rules which were adopted between the parties, which indicates that an award of an emergency arbitrator is included within the ambit of the rules, and therefore an emergency arbitrator means an arbitrator appointed in accordance with the rules itself. And therefore, that argument also was shot down. Now, the next point that was discussed, as I mentioned right in the start, was the Law Commission's 246 Law Commission's report, in which the commission had mentioned or had proposed adding of provisions relating to emergency arbitration, but these provisions had been scrapped eventually. So the Supreme Court held that the mere fact that a recommendation of a Law Commission report is not followed by the Parliament does not necessarily lead to the conclusion that what has been suggested by the Law Commission cannot form a part of the statute as properly interpreted. So they essentially said that, okay, it was proposed by the 246 Law Commission in its report, and it was not followed, but yet that does not mean that what was suggested, if we interpret the existing provisions of the Act, cannot fall within those provisions. And what the court also emphasized was another committee report. This is the Sri Krishna committee report, in which a high-level committee constituted by the government of India under Justice Sri Krishna, that is the famous Justice Sri Krishna, to review the institutionalization of the arbitration mechanism in India and look into the provisions of the Arbitration Act after the 2015 Amendment Act, had submitted a report in July of 2017, and which is known as the Sri Krishna Committee report. Now, in this report, very importantly, the Sri Krishna Committee had said that it is possible to interpret Section 17(2) of the Act to enforce emergency arbitration awards for arbitrations seated in India. That is only, as I mentioned, arbitrations in which the seat of arbitration is in India, and also recommended that the Act can be amended only so that it comes in line with the international practice in favor of recognizing and enforcing an emergency award. So therefore, even under the Sri Krishna Committee report, Justice Sri Krishna and the rest of the committee had said that it is possible to interpret that one can enforce emergency arbitration awards under Section 17(2). Of course, that is the next issue, but this was what had been discussed. Now, coming to an emergency arbitrators award, that is an order. What is the objective of the award? It's an order which would be an order which furthers two main objectives of the Act. The first is to decongest the court system, and secondly, to give the parties urgent interim relief in cases which deserve such relief. Now, given the fact that party autonomy is respected by the Act and there's no prohibition against emergency arbitrators being appointed, the court said that it is clear that an emergency arbitrator's order, which is exactly like an order of an arbitral tribunal once properly constituted, in that the parties have to be heard, reasons are to be given, etc., would fall within the institutional rules which the parties have agreed and would consequently be covered by Section 17(1) of the Act when read with the other provisions of the Act, as I mentioned previously. Lastly, the court held that, look, all throughout, Future Retail has participated in the emergency arbitration proceedings. So a party cannot be heard to say, after it participates in the emergency award proceedings, having agreed to the institutional rules made by the SIAC, that thereafter it will not be bound by the emergency arbitrator's ruling, as it is a nullity. So all along they went along with this emergency arbitration, and then only in the final stage did they say, look, the arbitrator had no jurisdiction, the award is a nullity, and therefore we are not bound by the award, which is what the respondents had done in this case. So the court said this is not a valid course of action. This conduct cannot be allowed, and therefore an emergency, once a party participates in the emergency award proceeding, it cannot then denounce it. So in conclusion, what the court said, and I'm now going to quote from the judgment itself, it said, we therefore answer the first question by declaring that full party autonomy is given by the Arbitration Act to have a dispute decided in accordance with institutional rules, which can include emergency arbitrators delivering interim awards, delivering interim orders described as awards. Such orders are important step in aid of decongesting the civil courts and affording expeditious interim relief to the parties. Such orders are referable to and are made under Section 17(1) of the Arbitration Act, full stop. And they also said that such orders are enforceable under Section 17(2) of the Arbitration Act in another part of the judgment. So, Jai, this is the first issue that was decided. Do you want to discuss anything on this, or shall I go on?
So you may please proceed, sir, because I have a couple of questions that I wish to ask at the end of the session. Sure.
Okay, great. Okay, so the next question or the next issue which the court decided, and I'm not going to go into it in too much detail, because as I mentioned, the first issue was more important. But the next issue is whether an order under Section 17(2) is appealable under Section 37 of the Act. What is an order under Section 17(2)? Once an order is passed under Section 17(1), that is an interim order by an emergency arbitrator, or even otherwise, if any order is passed under 17(1), then a party may seek to enforce it by making an application to the court under Section 17(2). And what does Section 17(2) say? I'll just read it out again for the benefit of the viewers. 17(2) says, subject to any orders passed in an appeal under Section 37. Any order issued by the arbitral tribunal under this section shall be deemed to be an order of the court for all purposes, and shall be enforceable under the CPC in the same manner as if it were an order of the court. Now, so therefore, once an order under 17(1) is made, a party may seek to enforce it under 17(2). by making an application to the civil court for enforcing the same under the Civil Procedure Code. Once that order is passed, that is an order under 17(2), which is passed by the court, then is that order appealable under Section 37 of the Act is what was discussed, is what was the question which was being discussed. And for a moment, let's just look at Section 37 of the Act and what it provides. Section 37 of the Arbitration and Conciliation Act provides for appealable orders. And it says in 1, notwithstanding anything contained in any other law for the time being in force, an appeal shall lie from the following orders and from no others to the court authorized by law to hear appeals from original decrees of the court passing the order. Namely, A, refusing to refer parties to arbitration under Section 8, granting or refusing to grant any measure under Section 9, setting aside or refusing to set aside an arbitration award under Section 34. Also, 2, an appeal shall also lie to a court from the order of the arbitral tribunal, A, accepting the plea referred to in subsection 2 or subsection 3 of Section 16, or granting or refusing to grant an interim measure under Section 17. So, under Section 37(2)(b), an order under Section 17, only an order granting or refusing to grant an interim measure under Section 17 is appealable, not an order under 17(2). This was the argument of the petitioners. And what did the court say? The court said there is no doubt that the arbitral tribunal cannot itself enforce its orders, which can only be done by a court with reference to the Civil Procedure Code. But the court, when it acts under Section 17(2), acts in the same manner as it acts to enforce a court order made under Section 9(1) of the Act. Now, Section 9(1) is an identical provision to Section 17(1) of the Act, wherein the same powers are now have been given to the arbitral tribunal as have been given to the court under Section 9(1) of the Act to pass interim measures of relief. So the court said that if this is so, if it is the same, if it acts in the same manner as it acts to enforce a court order made under Section 9(1), then what is clear is that the arbitral tribunal's order gets enforced under Section 17(2), read with the CPC. And there can be no doubt, the court also held that there can be no doubt that the legal fiction created under Section 17(2), that is, that an order under 17(1) is to be treated as an order under the CPC for enforcement of interim orders, is created only for the limited purpose of enforcement as a decree of the court. Now, to extend this fiction to encompass appeals from such orders is to go beyond the clear intention of the legislature. Essentially, if you were to extend this fiction to say that the CPC will apply even to orders under 17(2), and that means you can file an appeal under Order 43, Rule 1R, is incorrect. And I'll go into it in more detail, but this is essentially what the court held. The court further held that the respondent's argument in stressing that the words under the Code of Civil Procedure in Section 17(2) would apply to appeals as well holds no water, as a limited fiction for the purpose of enforcement cannot be elevated to the level of a genie which has been released from a statutory provision and which would encompass matters never in contemplation of the legislature. So the legislature had not contemplated that an appeal would lie under an order enforcing or refusing to enforce an order under 17.1. I'm sorry. So an order under 17.2, if it were appealable, there would be an amendment to section 37 of the Act to specifically include that orders under 17.2 shall also be appealable. But this was not done. And given the fact that the 2015 Amendment Act had provided in section 17.1 the same powers to an arbitral tribunal as given to a court under section 9.1, it would be an anomaly to hold that if an interim order was passed by the tribunal then enforced by the court with reference to order 39.2a, such order would not be referable to section 17. So I'm not getting into order 39 rule 2a, which is consequence for disobedience of breach of injunction, etc., etc. But the short point was that the court held that the Arbitration Act is a self-contained code on matters pertaining to arbitration, and a self-contained code by its very nature is exhaustive. The court also held that in previous cases, for example, in the BGS SGS Soma case of 2020, the Supreme Court had ruled out appeals under Order 43, Rule 1 of the Code when it came to orders being made under the Arbitration Act. So the court had held in this case, in the BGS case, that an order made under the Arbitration Act is only appealable under Section 37, not under Section 43, Rule 1 of the CPC. And further, the court also held that even after the 2015 amendment to Section 17, the section continued to, Section 37 continued to provide for appeals only from an order granting or refusing to grant any interim measure under Section 17. And therefore, a literal reading of Section 17 would show that the grant or non-grant of interim measures under Section 37(2)(b) refers to only Section 17(1) of the Act, not Section 17(2). In fact, if one goes to see the opening words of Section 17(2), which is a non-obstante provision which says that subject to any orders passed in appeal under Section 37, demonstrates the legislature's intention that orders that are passed in appeal under Section 37 are only relatable to Section 17(1) and not to Section 17(2). So the Supreme Court held that what is clear from this is the fact that enforcement proceedings are not covered by the appeal provision under Section 37. And lastly, the court held that there can be no doubt that Section 37 is also a complete code insofar as appeals from orders and awards made under the Arbitration Act are concerned. There is no other provision under the Arbitration Act or otherwise which provides for appeals for orders or awards made under the Arbitration Act. And the court held that this has been further strengthened by the addition of the non-obstante clause by the 2019 Amendment Act. And therefore, the court finally answered the question that the second question posed is thus answered by declaring that no appeal lies under Section 37 against an order of enforcement of an emergency arbitrator's order made under Section 17(2) of the Act. So, Jay, I've covered both the sections, both the issues. Would you like to discuss anything further on this?
Yes, sir. First of all, sir, I wish to thank you for this brilliant and outstanding presentation on Emergency Arbitration Award wasn't just informative, but extremely elaborate and insightful. And I'm sure that the session will benefit all our viewers. Just a couple of questions that I had, sir, if I may proceed with them.
Sure.
Yeah. So we all are aware that this award was passed by the emergency arbitrator under the arbitration rules of Singapore International Arbitration Center, which is also referred to as the SIAC rules, and in an Indian seated arbitration. So, hypothetically speaking, sir, had this been an issue before the Arbitration Council of India, do you think that the outcome would have been slightly different? And number two, role of Arbitration Council of India as an institutional arbitration, because now that we are aware that the original Act of Arbitration Act, which is 1986, was amended in 2015 to make it more user friendly, cost effective, ensure speedy disposal of cases, neutrality of arbitrators, and also to give boost to institutional arbitration. Then subsequently another amendment happened in 2019, wherein the act had aimed at encouraging and streamlining institutional arbitration by establishing an independent body, which is the Arbitration Council of India. Now, do you think Arbitration Council of India has achieved the objective, the purpose that the act was, enshrined in the act to achieve? Has it garnered the same success that Singapore or probably other institutions have? And number three, if I may add, between an ad hoc arbitration and institutional, which mode of arbitration would you prefer personally that has worked in India?
So I'll answer the third question first.
Yes.
Internationally, now the trend is to go to institutional arbitration. And the reason for this is that they have their own rules, their fixed rules, which are usually tested by courts and are enforced, especially LCIA, SIAC, all the major arbitration centers, the Hong Kong International Arbitration Center, MCIA even, they have their own set of rules. They even have their own set of rules for appointment of arbitrators, their own panels of competent arbitrators, etc. So I would say that the trend is towards institutional arbitration, certainly. Unfortunately, in India, we have not yet reached that stage where institutional arbitration is as common as ad hoc arbitration. And the reason for that is perhaps that cost factors could be one thing. Another factor could be lack of education or awareness, or the fact that there are plenty of lawyers who are available as arbitrators, as ad hoc arbitrators, and you need not go to an institution. But I see ultimately that institutional arbitration becoming far more common, especially in high stakes matters, especially in matters involving questions of thousands of crores of rupees, as we saw in this case. Because as you mentioned, there were billions of dollars at stake in terms of the second deal, and the first deal with Amazon also, there were thousands of crores at stake. So I see the trend going towards institutional arbitration, and I hope it does. Secondly, the second question you asked was about the Arbitration Council of India and whether it has achieved that objective of speedy redressal of arbitration, etc. Only time will tell. According to me, it will achieve those objectives. Look, India's avowed aim is to become the hub or one of the hubs of international arbitration. And for that purpose, I have no doubt that the government is doing whatever it can. In fact, they have started a international arbitration center in Delhi as well. The Arbitration Council of India is a very different and unique step that has been taken by the government in amending the act. Only time will tell. I'm not going to venture a guess on this, but I think it's a positive step and it's definitely a good step in the correct direction. And the trend is a pro-investment stance, a pro-arbitration stance, and a pro-enforcement stance of the Indian government, which is reflected also in the judgments that are being passed by the Honorable Supreme Court and various high courts. And lastly, you mentioned that whether a similar outcome would have been achieved had it been an Indian based institutional arbitration center. And I don't see why not. I think ultimately the courts were bound to allow emergency arbitration. And so even if an emergency arbitrator had been appointed by an Indian-based center or by parties who had agreed to institutional arbitration in India, although even in this case it was an Indian-seated arbitration, then a similar outcome would have been achieved in terms of a judgment of the Supreme Court. But I also have the highest regard for the Supreme Court in terms of the approach which they've gone with in this judgment. It's a very pro-arbitration approach, which is desirable if we have that intention of becoming a hub of arbitration. And the only difficulty I really have with this judgment, and it's not really a difficulty in terms of it's achieved the right outcome, but I don't know whether it was the right way, is that as we discussed, or as I mentioned, the court has read into the current provisions of the Arbitration and Conciliation Act permissibility of emergency arbitration without actually amending the act. Of course, the Supreme Court is entitled to do that, and it can read into the provisions or the existing provisions the possibility of emergency arbitration and emergency awards. But I would have preferred an amendment come through. But of course, if the same effect is reached just by the judgment of the Supreme Court, then there can be no difficulty with that.
Definitely, sir. I'm sure that this judgment has contributed to the development of Indian arbitration law. I mean, obviously, it is a huge victory for Amazon, but in the broader scheme of things, I think it is a huge victory for Indian arbitration and a huge sign of relief for institutional arbitral institutions that are there that have newly opened up. So, thank you so much, there, sir. Anything that you wish to say in the end to conclude the session?
No, I just want to thank you, Jay, for having me here. It was enjoyable. It's good to even reach out to people, to speak to people about topics that are interesting, and it's great that you are doing this. So keep it up and all the best.
Thank you so much, there, sir. It really means a lot coming from you, and I mean, there couldn't have been a better session on this very topic. So thank you so much for that, sir. And our email is mentioned on the channel. So to all the viewers who are watching, in case of any of the queries, do reach out to us on that email that is mentioned on the channel. We'll be more than happy to forward the same to our amicus for today's session, Mr. Anirudh Hariani, who joins us from Mumbai. So thank you so much, sir, once again. Really means a lot that you took out time from your busy schedule for this segment on emergency arbitration in India. And I'm sure that this would immensely benefit all our viewers who are watching. So thank you so much, everybody. It's goodbye for now. Thank you, sir, once again.
Thank you. Thank you.